to know. All right. Good morning, everyone. Thank you so much for being here. This is our Family Justice Institute. My name is Natalie Olias. I work with the Contra Costa Family Justice Center. I'm very excited to be the host for this workshop today. This is brand new in terms of thinking about our criminal justice system. Our two speakers for today are going to be Eric Dixon, who's a Deputy District Attorney with the Contra Costa District Attorney's Office, and Brandon Banks is the Chief Assistant for the Public Defender's Office in Contra Costa County. Before I let them take it away, if folks have questions as the slides get going and the training gets started, please feel free to put them in the chat or ask them in the Q&A. I'll grab those, and then at the end of the training, we'll make sure to get those questions answered for you. And then feel free to still introduce yourselves in the chat, but Eric and Brandon, I'm going to let you both take it away.
Okay. Thank you. Thanks everyone for being here. I'm going to start the screen sharing. And I'll just introduce myself a little bit. I've been a deputy DA for around a dozen years. Been in the domestic violence unit for about 5 years. I'm currently stationed at the Family Justice Center in West County, which is our Richmond office. And I file cases, mostly felony cases, and also do some trial work, some kind of a hybrid filing and trial attorney position. Brandon, do you want to introduce yourself?
Sure. Thank you, Eric. Good morning, everybody. My name is Brandon Banks. I am an attorney here at the Contra Costa County Public Defender's Office. I have been an attorney since 2002, so a little over 20 years. I am currently the chief assistant with the office. During my time with the Contra Costa County Public Defender's Office, I've had a variety of assignments. I spent a long time in the general felony unit, handling felonies. After that, I worked in the clean slate unit, and then in 2020 became a part of the management team, and I am now in the chief assistant role. So thank you, Eric.
All right, so we'll start with, assuming it starts. Basic question, criminal law, how is this different from other types of law like family court law or divorce? Contract disputes, slip and fall cases, personal injury, stuff like that. What's the difference? And the difference really comes down to what the court can do. And in the criminal law, the court has the power to sanction by way of depriving someone of their liberty. That's one of the big differences. Philosophical question for you: why would we have criminal law as opposed to just adjudicating all of our problems with civil law? That's a conversation for you to have over dinner with your friends, and to get very deep into the philosophical reads. I did that in my crim law class, and in law school, we're crim law 101 here, so we'll just skip over that philosophical question. Sources of the criminal law, for the most part, that comes from the penal code for California. There are other codes, health and safety or vehicle code, a couple others that would create crimes, but for the most part, it's coming from the penal code. And then federally, it's coming from that code section or title. And as a local prosecutor, I don't do any federal cases whatsoever. Brandon, do you do federal cases?
I do not.
So we only work in state law. So we're in California Superior Court only. Federal system is totally separate from what we do. So how does a case get filed? So here's the flow chart. There's a crime that happens. Someone reports it. The police show up. They will then write a report. That report gets submitted to our office. And then we will decide whether to file charges or to not file charges. So my predecessor decided to use the monopoly card there, and that's the no charges filed, and then the other in the courtroom is charges filed. Things, it may not quite look like that. Sometimes I'm reviewing cases and the person isn't in custody anymore. And they're reviewing a case that's several months past when it happened, so there's no get out of jail free card there. Just charges aren't filed. So what is it that a prosecutor is looking at to file a case? So there's two things as a domestic violence prosecutor that I'm looking at, but I would say prosecutors are probably looking at both of these. One is what's the evidence from the crime that was committed, and the other is what's the prior criminal history. So if we're looking at evidence from the crime, then we're talking about eyewitnesses to the crime, forensic evidence like DNA or fingerprints or ballistic imaging, which is guns. Then there are, photos taken of the crime scene or the injuries to parties. We've got photos of that. Sometimes there's video like body worn cameras that police officers would have. Sometimes there's surveillance video from maybe a neighbor's house, or it happened at a commercial area and there's a camera there. A 911 call would be helpful. You're trying to get at almost a narrative of what's happening and why it's being reported. And then the last little photo there is cell phone tower. Sometimes you can get cell phone tower data that would locate the suspect near the scene of the crime. Not an exclusive list, of course. Prior criminal history. Generally, you're looking at a rap sheet. Everyone has probably heard that from Hollywood. So that's a record of arrests and prosecutions. That's what RAP stands for. And you might consider prior police reports and prior convictions. So the rap sheet would give you the convictions that someone has had previously, and it would also tell you prior arrests, which would then alert you to the existence of prior police reports. Restraining orders. So what that means, or what that's talking about, is domestic violence restraining orders after hearing. So there'll be an application for that. That application will often involve allegations of domestic violence. So you're looking at that to see what the history is. And the reason why you're looking at that, particularly as a domestic violence prosecutor, is because there are these evidence code sections that allow for the introduction of prior crimes. As a default rule, prior crimes are inadmissible. So that's evidence code section 1101A. 1101B has some exceptions to that rule. 1108 and 1109 are other exceptions. To work backwards, 1109 is prior crimes of domestic violence. So if you're evaluating a domestic violence case for filing, you're looking at, is there a history of domestic violence? 1108 is prior sex offenses. And there's crossover for me with sexual assault offenses and domestic violence offenses. So if there are prior sex offenses, then that would be admissible under 1108. And 1101B, I have to go back to law school to remember what those are, but I believe we're talking about motive, identity, intent, common plan, and then something else within. Is that modus operandi? Brandon, do you remember?
Yeah, or scheme.
Yeah. So that's basically where that's coming in from. One thing that I'm not considering when filing a case is the victim pressing charges. And you've got all these Hollywood shows here to make the point that this is kind of a creation of Hollywood, that whether cases can proceed or not depends on whether the victim is pressing charges or not. That's not something that I'm considering when I'm deciding whether to file a case or not. There are jurisdictions that consider that. Contra Costa County is not one of them. So we're evaluating the case based on evidence and prior history. not on whether the victim wants to press charges. So if the case isn't strong enough to file and the victim wants to press charges, I can't file. And similarly, if she doesn't want to press charges, but it's a strong enough case to file, then I'm still going to file. So what does that mean when I say, is it a strong enough case? The burden of proof at trial in criminal cases is beyond a reasonable doubt. Probably you all know that, because Hollywood does a good job of telling you that as well. But what does that really mean? It means that you have to have enough evidence that 12 random people from the community have to be convinced, and they have to have an abiding conviction that the charge is true. It's a very high burden of proof. So I'm going to say something nice about Brandon here, even though we're, opposing counsel. A lot of times I hear people say things like, "Oh, this guy doesn't have a chance because he doesn't get a real lawyer. He's stuck with a public defender." And I'm here to tell you, public defenders are good attorneys. They are well-trained attorneys. By the time they get into felonies, they are trial tested. They are battle ready. If you file a case that is not sufficient to get a conviction, they're not going to be scared and think, "Oh, well, they filed charges. I guess we're going to have to plead," or, "Ooh, we're so scared." That's not going to happen. They're good attorneys. They're going to look at the case and evaluate it. And if it's such a weak case, they're just going to say, "Go to trial then. We'll win at trial." So it's kind of that would be a waste to just file cases where you don't think you've got enough evidence. And it's a massive use of resources for clerical and law enforcement, civilian witnesses who might have to come in. It's a lot of resources. There's no reason to file a case when you can't meet that burden of proof. So when I'm looking at a case, I'm looking down the road at trial. Is there enough evidence at trial to win this case? That's just that's how it is. I play the long game and make the best decision in that way. Brandon, do you disagree? Do you think you're not capable of evaluating your case?
No, I think you gave a really good summation of what you on the prosecutorial side consider when filing cases, and part of that consideration, I presume, is the Public Defender's Office in Contra Costa County really taking a strong position in holding the DA's office to their burden in establishing that the crime was in fact committed.
Yep, absolutely. Okay, so how does a case get filed? These are 2 tracks, even though there are 3 words there. It's 2 tracks. So the most common is that our office will file a criminal complaint. That starts the case. There's another document later that gets filed called an information. And it looks exactly like the complaint, except that it says the word information on it. The other route is by indictment, and that it goes through a grand jury. There's no subsequent document filed after the indictment. It's just an indictment. So, well, I just told you what a complaint was, or how it starts. But basically, it's a list of charges and some pleading language that notifies the defendant of the charges. And that pleading language basically just tracks the statute. The information, again, just like the complaint, but it's filed after what's called a preliminary hearing, where a judge says these charges can move forward to trial. And then the indictment is with the grand jury. The grand jury hears the evidence and says this case can move forward for trial. So those are the 2 tracks. There's a judge who's going to say these charges can move forward, followed by an information being filed, or the hearing is in front of a grand jury, and the grand jury says the case can move forward and an indictment is filed. So here's an example of an information. So up here, you see the information felony, and then it has a list of charges, and then the pleading language, and then the redactions there to take out the defendant's name. But that's basically what the charging document looks like. All right, so this is the Crim Law 101 version of the major stages of a case. There's a complaint filed, then there's an arraignment. The arraignment is when the judge notifies the defendant of the charges. Brandon, are you comfortable kind of explaining what an arraignment is?
Sure. So at the arraignment stage is when the individual who's charged with the crime will make their initial appearance before the judge. At that time, in the courtroom, there will be the judge, of course. There will be a prosecutor, and there will be a defense attorney with the person who has come before the court to face the charges. More often than not, for a variety of reasons, that defense attorney, at least in Contra Costa County, is an attorney who is employed by the Public Defender's Office. At the time of arraignment, the individual who's accused of the crime will enter a plea. It is almost exclusively a plea of not guilty. Then once that individual enters a plea of not guilty, the court will set dates, future court dates for the individual who's accused of the crime. Depending on the person's incarceration status, those dates will change. And also depending on the person's incarceration status, the person has certain speedy trial rights. So if a person has been charged with a felony, that person has a right to a preliminary hearing within either 10 court days or 60 calendar days. All people, irrespective of their custodial status, have a right to a preliminary hearing, which Eric is going to talk about in just a moment, within 60 calendar days. But those people who are incarcerated also have a right to a preliminary hearing within 10 court days. The reason that exists is because there's a recognition that people who are incarcerated are, of course, presumed innocent, and we don't want people languishing in custody without having due process as soon as possible. I should also note that at the arraignment stage, that's also an opportunity for the individual to have their incarceration reconsidered, specifically people who are in custody. At that time, the defense attorney can make a request of the court to have the person released pending the outcome of the case.
Okay. Remember, I think I did. Yeah. All right. So I should have done this to get to Brandon, and then it would look real smooth. Anywho, we're on to the preliminary hearing stage. Again, that is the judge is deciding, is there enough evidence to move forward? The burden of proof here is probable cause, also meaning strong suspicion. Is there a strong suspicion that this crime was committed and the defendant is the responsible person for committing the crime? In California, the police can testify for victims and witnesses. The proposition that was passed called Prop 115, and this is commonly referred to as Prop 115 testimony. That is not always the case that a police officer testifies on behalf of someone. It's a discretionary decision that the prosecutor makes. So the prosecutor who's assigned makes as to whether the victim or witness should testify in person or whether the police officer can testify on their behalf. So a prosecutor is calling witnesses, and asking them questions, and they answer those questions. And the goal is to meet the burden of proof that there's a strong suspicion crime was committed. A preliminary hearing tends to be shorter than a trial. Number one, the burden of proof is lower, so you don't necessarily need to present all of the evidence that you have. And the defense, I'm not going to speak totally for Brandon here, but the defense may be not wanting to put on a full case that they might want to put on at trial for tactical reasons. But they're allowed to ask questions as well of the prosecutorial witnesses. And then the judge makes a decision on whether the case can move forward. Brandon, anything you want to add on preliminary hearings?
I think that's a really good description of what typically takes place at the preliminary hearing. The only thing I would add is that that is often a time where the defense will, if the person again is in custody, that's a time for a discussion to take place after the conclusion of the preliminary hearing to talk about whether or not the person should be released based on the evidence that was presented or the lack of evidence that was presented. It's also a time to discuss with the court whether the charges should be reduced based on either the evidence that was presented or based on mitigation that might be presented by the defense.
Yeah, so that last bit is from Penal Code Section 17. So if you're in court and you're listening to the attorneys talk, they'll say, I've got a Section 17 motion, and maybe the prosecutor will say, I oppose the Section 17. That's what they're talking about, is whether the charges can be reduced to misdemeanors. So in California, we have charges that can be prosecuted as both a felony and a misdemeanor. And if the prosecutor files it as a felony, a judge can reduce it to a misdemeanor for the reasons that Brandon just gave me. All right, then there's an arraignment on an information. And that goes kind of the same as Brandon just told you with the prior information. At this second arraignment, there is a statutory right to a speedy trial within 60 calendar days. And a defendant can waive that, or a defendant can demand a speedy trial, and then the court would set it accordingly. Brandon, can you think of anything else distinct on that second arraignment?
No, it really is largely kind of a repeat of what occurs at the initial arraignment.
Okay. And then there's a jury trial plea I added in here, or dismissal. A case can end in those ways. There's either going to be a trial, there's going to be a resolution in the case, or the case could get dismissed. And maybe we'll get into that, but there are a number of ways that can happen. So I guess I'll see if Brandon wants to get into that later. On how fast this can happen, so that's the rabbit telling you that's a very fast procedure. And you should start with, say there's an arrest and the defendant is in custody. Our office files while the defendant is in custody, and then there's an arraignment. That process would be maybe 4 days at the outer end of it. Then you'd have that preliminary hearing within 10 court days, so that's about 2 weeks. Then, Brandon, do you remember how long the gap is from preliminary hearing to arraignment? Is that 3 weeks?
It is approximately 3 weeks, correct.
Okay. And then you got 60 days to the trial. So we're in the neighborhood of 4 months at a maximum for like the fastest it could possibly go. From start to finish, unless there's a dismissal, which could happen. It could happen at the preliminary hearing. And then it could go very slowly. And that is represented by all these settings. It's not that nothing is happening in the case and there's just these settings. Often what is happening is that additional investigation is happening from both sides. Could be the prosecution and the defense are collecting additional evidence. And so you don't want to have a preliminary hearing until you've got all the evidence. Sometimes it's a discovery issue. So my office has an obligation to provide discovery to the defense. And basically both sides just want to make sure that everyone has that. And so then we do that and wait until both sides are ready for the preliminary hearing. This usually will happen with time being waived. So Brandon said you've got the 10 court day rule and the 60 calendar day rule for the preliminary hearing. The defendant can waive those, and then you're outside of that 60 days. Once you get outside of that 60 days, maybe both sides are ready for a preliminary hearing, but the court is unavailable because the court has too many cases. And the prelim gets continued to a future date, 6 to 8 weeks later. And then you show up for that court date, and one of the officers is on vacation. So the people can't proceed with the case. So then it's continued again. And that can happen for a long time. And that can make a case take many years to get to completion. And then I put in some motions there as well, because there are a number of motions that could be filed, and that those could result in dismissal of the case, or they may simply add additional time to the case. Let's see. It's not the major stages that are taking all the time in the case. It's usually these settings and motions that will extend the case. And when I say extend the case, I mean by years. The case can go on for years before it's over. Brandon, anything to add on how fast or slow the process goes?
Yeah, what I would add is that often what dictates cases taking a longer amount of time is the complexity of the case, and the oftentimes there's a lot of overlap between the nature of the charges. Usually the more serious the charges are, usually the case is more complex, which means that there's going to be more discovery, there's going to be more investigation, probably more motion work to do. And so that often leads to the cases becoming lengthier and taking a longer time to either get to trial or to resolve before trial.
Yeah, good point, man. Let's see. All right, who's who? On the prosecution side, there are the police officers or the sheriff's deputies. There's the district attorney, there's an investigator from our office sometimes, and then there are victim advocates employed at our office who advocate for the victim. On the defense side, there's a defense attorney, there are defense investigators. And for judicially, you have the judges, and then probation officers who are sort of monitoring probationers on behalf of the courts. Brandon, I kind of guessed it, everyone in your office. So if you want to add people who are involved, feel free to do so.
Sure. And Natalie knows a lot about this. I think another critical part of our defense team are our social workers. And we may discuss this later on, but part of the modern criminal defense approach, at least with public defenders and our office in particular, is taking this holistic approach with our defense representation. And so that includes not only the attorney, the investigator, who are kind of the classic parts of the defense team, but also adding in a social worker and a legal assistant, so we can provide a wide variety of services to our clients that often have a positive impact on the outcome of the case.
Okay, so if we go to trials, then we're usually in front of a jury. So unlike a preliminary hearing, which is in front of a judge, we're now in front of a jury. The judge is still there, and everything is in person. There's no testifying by Zoom or having a deposition and just having the deposition testimony in. We don't do depositions in criminal law. It's an in-person trial, the defendant is present for the entirety of the trial. And it's done on legal procedure, I guess is what my predecessor wanted with this photo. The way the trial starts is with motions in limine, and that is kind of the rules of the road for that particular courtroom. But basically what's happening in motions in limine is everyone is getting clear on how we're going to do the trial and what evidence is admissible or inadmissible. And then once you have that, I mean, hopefully that's done before you start, but sometimes the judges want to move forward and then you bring in the jury before you've actually finished all the motions in limine. But then you do jury selection. That's sometimes called voir dire or voir dire if you're from the South. And once you get through selecting the jury, 12 jurors and 1 or 2 or 3, depending on how complex the case is, alternate jurors, then the case kind of then actually will start, and you'll have opening statements, and then it's presentation of evidence. So the prosecution will go first, and they'll call witnesses and admit exhibits, and then at the conclusion of the prosecution case, then the defense is allowed to present a case if they choose, and at the end of that, you have closing arguments, and then the jurors will go and deliberate and decide if they can reach a verdict. So their verdict can be for conviction, meaning they believe the defendant is guilty, or they can vote for an acquittal, which means they think the defendant is not guilty. The third option there would be they can't reach a verdict, and then you have a hung jury, which will result in a mistrial, and then the case kind of goes back to pre-trial. And then if the verdict is guilty, there will be a sentencing. I believe that's about 2 weeks later by timing, or the defendant can waive time for sentencing, which is, I think, is more common. And then you'll have a sentencing date at some point in the future. Anything you want to add to the trial, Brandon?
I think that's a great description of what a trial typically looks like.
Yeah, I'll add one more thing. Unlike on TV, it's not a packed courtroom full of interested observers. It is often just the parties, and that's pretty much always the case at preliminary hearing. There are no camera crews outside waiting or anything like that. Most cases, however, do not go to trial. Most cases will resolve by plea. And there are 3 pleas that can happen. There's a guilty plea, a no contest plea, or a not guilty plea. So as Brandon mentioned when he was talking about the arraignment, at arraignment, that's got to be like 99.9% of the time, the plea is not guilty at arraignment. And that's because the parties have not had any chance to negotiate about the case. So they're not going to just come in and say that they're guilty. But when a case does resolve by plea, most of the time that is by no contest. Brandon, I think you're best positioned to explain the guilty versus no contest plea.
Okay. So in the criminal context, it really is a difference without much of a distinction. The person, should they decide to plead either guilty or no contest, they are liable. They're admitting liability or culpability for whatever they are pleading guilty or no contest to. They are agreeing to abide by whatever sentence has been discussed and determined by the relevant parties. I suppose the one reason to enter a plea of no contest is that it does provide some limitation of civil liability should that become an issue. But for our purposes in the criminal court system, the distinction is not all that significant.
All right. I think I'm gonna go through sort of the outcomes and then maybe you can talk about what goes into the plea.
Sure.
So possible outcomes would be there's a county jail sentence. I'm just doing the basics here. It's a wide variety of things that could happen, but often there is a county jail sentence, and that is 0 to 364 days. And that is by statute at 50% credit available. So a 364 maximum sentence is 182 actual days in custody. Probation can be court probation, but at the felony level, it's typically formal probation, meaning there's going to be a probation officer assigned to the particular probationer. Sometimes probation can have what's called a suspended state prison sentence, which would mean you're not sentencing the defendant to prison, but it's sort of the last chance. The defendant is going to be on probation, but any violation of probation would mean you'd be sentenced to prison for whatever that sentence is. I'd say these are far less common now than they were when I started. I don't know if Brandon agrees with that or not, but that's what I've seen. And the other possibility would be a prison sentence, and how long that prison sentence is and the credits that are available depend on the crime. And I'd say it also depends on what you do if you're in prison, because there are incentives to do certain programs like educational programs in prison that can then result in you getting credit toward your sentence. Standard length for probation is 2 years for felonies and 1 year for misdemeanors. Those are basically the typical terms. They're basically just saying you're going to obey the law and report any law enforcement contacts that you do have. There can be additional terms added on to probation, like you're supposed to test for drugs and make sure that you're not doing drugs, and or you could be agreeing that you're going to go do a drug program as a condition of probation. And then in the domestic violence context, the terms of probation are going to derive from Penal Code Section 1203.097. And that is determined based on the relationship of the parties, not based on whatever the crime is. So if it's a vandalism, but it's a vandalism between a husband and wife, or maybe a ex-boyfriend and girlfriend, then they're going to have domestic violence terms because of the nature of the parties. The 097 terms will require a 52-week batterers intervention program, one that's approved by probation. And the term of probation has to be at least 3 years. It can be more by agreement. So that would be an agreement between usually the prosecution and the defense as to how long that term of probation would be, but it can be longer than that. Again, and that depends on the crime, which is getting too complex for criminal law 101. Let me see what my next slide is. All right, prison sentences. So 1178 is kind of the default sentencing for prison sentences, and our sentencing scheme in California for most crimes is determinate sentencing, meaning there's a determinate amount of time that the sentence is for, and that runs in triads. So there are 3 options: 16 months, 2 years, 3 years. 273.5, which is a common domestic violence crime, is a 234, and then a 192, which is a manslaughter or voluntary manslaughter, would be 3 years, 6 years, 11 years. And so those are the possibilities. So if it's a manslaughter, you can't sentence a defendant just on a manslaughter charge for 4 years or 7 years. It has to be one of those triads. And probably how that is determined would be best addressed by Brandon when he talks about what's involved in a plea deal. Let's see. Okay, so some crimes have to be served because of Assembly Bill 109. This was, I believe, 2011 when that became effective. So if it's a crime that's punishable under 1170H, then the crime or the sentence is served locally rather than in prison. And there's an additional change there, which is that a portion of the sentence can be mandatory supervision, which is kind of like probation. It's also kind of like parole. And those are called split sentences. And you can split a sentence kind of however the parties decide to split it. But that's one final distinction there. Only some crimes can result in a actual prison sentence now. And once someone has served that sentence, if you're sentenced to prison, you'd be released on either parole or post-release community supervision. And if it's on, and the distinction there, as I understand it, Brandon can correct me if I'm wrong, is who's doing the supervising? Is it the state parole agent or is it the local? Basically, it's a probation department that supervises on DRCS. All right, Brandon, I'm gonna stop there
Okay.
and let you
All
talk
right.
about please.
Okay, and so is this where I take everybody behind the curtain of what takes place usually between the prosecution and the defense when we are potentially talking about resolving a case? So this can happen at almost any point during the time that the person has been charged with a crime, any time during the court process. So what often happens is once the defense gets a case, we review the discovery, we have a conversation with the client that we are representing. Sometimes we will reach out to the DA, the assigned DA, to talk about potentially resolving the case. Sometimes the DA will reach out to the defense attorney to talk about potentially resolving the case. There are probably, and Eric can talk about this as well, probably a couple of pressure points during the case when the discussions really kind of amp up about potentially resolving the case. Usually it's before some sort of hearing because there might be an incentive on both sides to resolve the case before doing the hearing, bringing in witnesses, because there is sometimes an unknown with what might happen during one of the hearings that takes place during the criminal court process. So if we're talking about a felony before the preliminary hearing, there will often be an opportunity for the defense attorney and the prosecutor to talk about potentially resolving the case. Another critical point is perhaps right after the preliminary hearing, because more information might have come out at the preliminary hearing, more evidence might have come out at the preliminary hearing that might change the nature of the case, where the charges might have been demonstrated that they're not quite as easily proved by the prosecution. So there might be some room there to resolve the case. Sometimes after a preliminary hearing, it might be shown that there is the potential to charge even more serious charges, which also might incentivize the defense to talk to the prosecution about resolving the case. So that same thing can happen just before the trial or as the trial is about to begin. There is often an incentive to have a discussion between the parties about potentially resolving the case. So once the parties reach an agreement on the case, then they will take that proposed resolution to the judge. In Contra Costa County. More often than not, if the parties have reached an agreement on resolving the case, the judge will agree with that agreement. There are the rare occasions where the judge will not agree with an agreed upon disposition of the case because they think more often than not, if they don't agree, they think that the resolution is probably not as serious as the punishment is not as serious as they would like. But the vast majority of the time, the judge, if the parties have reached a conclusion, the judge will agree to that resolution. The person will then enter their plea, often no contest, as we discussed before, and the person will be voir dired by the judge, meaning that the judge will ask that person if they understand their rights before giving up their rights to enter that plea of no contest or guilty. And the judge will also ask the individual whether or not they understand all the terms and conditions of the plea. So if that person has agreed to a resolution that involves probation, the judge will talk to them about what their terms and conditions are related to probation. If that person has agreed to a resolution that might involve a prison commitment, the judge will talk to them about their agreement to abide by the conditions of parole once that person is released. So that is just a brief description of how we often arrive at a resolution and kind of the points at which a resolution might take place during the criminal court process.
Sounds good. Okay. One thing that Brandon said there reminded me, there's no slide here saying how the process is different from misdemeanor crimes. There's no preliminary hearing, so there's no probable cause finding. It just starts with a complaint. And then thinking back over a decade for me, I believe the timings are 30 days from arraignment for a misdemeanor trial if the defendant is in custody, but 45 if out of custody. Is that correct, Brandon?
That's correct.
Okay, so that's basically it. And then the pressure point there is usually right before trial to talk about a resolution. So that's all I've got. Brandon, you have anything else you want to add?
No, I think that was great, Eric.
Thank you, Brandon. All right, now we're ready for questions.
Good, we have several. Do you want to take down the slides for just a minute?
Yeah.
Thank you. Okay, so one of the first ones is who gathers or collects most of the evidence for a case? Is that the police or would that be the district attorney's office?
That's the police.
Okay. And then in terms of, and thinking back over to the complaint versus an indictment doing the grand jury route, what determines which route you take? Like, is there a decision on your part that we're going to go this way versus this way, or is it the case kind of dictates that?
It's based on the case usually.
Okay.
And just what's the best way to present that evidence. So, for example, if you have, sorry, if you have a lot of witnesses and it's kind of a complex case that would take many days to present at a preliminary hearing, then you might choose to do a grand jury. Because when a grand jury sits, they are sitting usually for like 2 weeks or 3 weeks. And so you've got this large block of time, and as long as you've cleared the schedule for your witnesses, then you can make sure that you can present the case in that way. If you're doing it by a preliminary hearing, you know, as we discussed earlier, there's a 10 court day time window to put that case forward. And you may not be able to do it because of the complexity of the case. So that'd be a reason why you might choose to go with an indictment in front of the grand jury.
Got it. Okay. Thank you. And there's a question that's asking around financial ability to be able to pay bail. So if somebody was just asking, is California a state that keeps individuals detained if they are unable to pay their bail, what the bail amount has been set at?
Brandon, I think this one's for you.
All right. So the short answer is yes. There was a seminal case called the Humphrey case that actually involved it's a local case in San Francisco. The individual's last name was Humphrey. And so the appellate court took the position that someone should not be able to be kept in custody merely because they cannot afford to pay bail. Now, that was the basis of the decision. Over time, courts have for better or for worse, refined that initial decision. And part of the consideration now, beyond whether or not someone has the ability to pay bail, is whether that person is quote unquote a danger to the community, or are there less restrictive alternatives to bail that can ensure that the public remains safe. Now, these are all kind of legal terms of art that provide a lot of space for the defense to argue one thing and the prosecution to argue the other, in terms of what are less restrictive conditions than bail that can make to achieve public safety. But the vast majority of the people that are charged with felonies are often people that are often unhoused. Almost all of them don't have the ability to pay bail. So there is, I wouldn't even call it a disproportionate amount of people who are in custody that are impoverished. It's probably the vast majority of people who are in custody that don't have the ability to pay bail. So despite, at least from my perspective, despite the Humphrey holding, there still are significant barriers to releasing people while they're waiting to have their case heard. Now, I will say that in Contra Costa County, and we may get to this a little later on during the questions, we have the pretrial services program, which is run through probation. And it's actually a pretty successful program where probation does an analysis of whether or not they believe the person who is coming into the arraignment and is charged with certain crimes, whether or not they believe that they can provide enough of a framework for that person to have them released into the community pending the disposition of the case. And so the court and the DEA and the defense oftentimes rely on that assessment. And that has actually led to people who probably would not have been released to be released, because those people are going to be supervised by probation, and those people are going to be connected to community-based resources to address some of the root causes which might have led to their incarceration in the first place.
Thank you. How common would you say it is for a case to go all the way to jury trial? Would you have a guess on the percentage of cases?
I have not seen any data. Brandon, have you seen any data? My guess is like single digits, but.
Yeah, in terms of percentage, as Eric mentioned earlier, the vast majority of the cases resolve before the trial. I think, and Eric probably shares this, and I think actually that the Judicial Council backs this up, because they do release data in terms of the number of trials in each county that take place annually. Contra Costa County historically has been a very litigious county where compared to the other counties in California, proportionally speaking, far more cases go to trial, both the felony level and the misdemeanor level. And even in a county like Contra Costa, where their cases go to trial at a higher rate, still, even in Contra Costa, the vast majority of the cases still resolve.
And is the criminal justice process different for an individual who does not have legal status in this country?
So in terms of the process itself, No, it's the same. In terms of resolutions to cases, it can be different. So often the defense will let us know that that's an issue, and then a plea deal is going to take that into account. If you can reach a plea deal, it would take that into account. So that'd be the difference that would happen. Brandon, can you think of anything else?
Yeah, I think that that essentially describes it. I think that sometimes the person who may have immigration status that can be impacted by criminal proceedings might also have immigration court going on at the same time, which is a civil process. But as Eric alluded to, the prosecution is mandated by law to consider someone's immigration status, and specifically how the charges or potential convictions might impact their immigration status. So it doesn't necessarily mean that they will make an immigration safe offer, but they are mandated to consider the person's immigration status when considering what offer to make.
Got it. Okay, thank you.
And sorry, just to add on. When we're talking about how the deal might change, generally we're talking about the charge that is pled to, and then frequently the length of the sentence.
Okay.
So the length of the sentence could trigger an issue or the type of the charge. So that's what you're working with in that situation.
Okay. Next question is, if there's a case that is both in criminal court and family court, and the family court makes a decision, can the district attorney's office can the criminal court judge overturn that decision?
So they're separate courts, and I'm trying to think of a decision that a family court judge might make that then a criminal court judge would overrule. So they're not going to review a decision, but they might make decisions that would affect what happened in family court. So, for example, you might have a restraining order in family court that allows for certain visitation. Then there's a crime that occurs, and the criminal court then issues a criminal protective order that says no contact. That criminal protective order takes priority. And then to go in reverse, often at the conclusion of a case, a criminal protective order is issued. Again, these are in domestic violence cases. And one of the boxes in that protective order will say, allow for peaceful contact for exchange of children as stated in any family court order that happens after this. And so then if there's a family court case after that, that allows for visitation, then that's fine. So you affected the criminal protective order, but it's sort of provided for in the criminal protective order.
Okay.
Brandon, can you think of anything else?
No, I think you described it exactly as it is.
Okay.
Thank you. How has Prop 47 impacted the DA's office ability to prosecute cases? Is it harder to prosecute them?
So Brandon is looking forward to this answer from me. So what Prop 47 did was reclassify mostly theft crimes from felony down to misdemeanor. And you can still prosecute the crime at a misdemeanor level. So that didn't change the ability to prosecute. What I will say is that resources in our office are not infinite. So you have a finite number of misdemeanor prosecutors who suddenly got thousands more cases than they had before. So there's an impact on the potential from our office to prosecute those crimes. I'll say that much.
Okay. And somebody's curious specifically about sexual assault offenses. Sometimes it feels like sexual offenders receive shorter prison term sentences. And there's a follow-up question to that, but I'll leave it at that for right now.
Well, I'll let Brandon talk on this as well, but I'll just say that it's when you hear the sentences in court that are like 700 years or 500 years to life, those are sex offense crimes. So go ahead, Brandon, do you have any?
I think if we look at the data, I think in terms of sentences related to individuals convicted of sex crimes, I believe the data shows that those individuals on the whole, receive far greater sentences probably than any other crime in the criminal court system. Would you agree, Eric?
Yeah, that's what I was getting after with the 500-year sentences. I will say, I remember was it Brock Turner, the Stanford swimmer guy? Like there was a lot of fallout from that sentence, which was a 180-day sentence.
Yeah.
So maybe that's what's driving that question, but I would say that was kind of out of the ordinary a bit, although I don't think that was a crazy sentence for any defendant who has no record prior and then commits a crime.
And at the risk of putting too fine a point on it, I think it's the few cases that you hear about that might receive a sentence that is an outlier. And oftentimes, I think what the public does not hear regarding those cases is perhaps the problems of proof, the circumstances related to the evidence involved in those particular cases. So I think that there is almost to a case with those kinds of outcomes that I think people are focused on. There's usually something significant that impacts what occurs in those cases.
Yeah.
So summary is really, you're looking at each case differently because each case has different sets of evidence, different witnesses and all. So that's going to dictate what type of sentence gets applied. So even though it feels like, well, a child was molested in a situation in say 2 different cases, one could get a significantly different sentencing versus another.
And once someone's convicted, they're like with the sex sentencing scheme in particular, there are requirements in terms of what the court imposes with those sentencing schemes. And so once it reaches if there's a trial and there's a conviction and there's a sentencing, the judge has less discretion in terms of what that person is sentenced to. And by less discretion, I mean that oftentimes, even if the court wanted to reduce the sentence, they are precluded from doing so because of the requirements of what the person must be sentenced to.
Got it.
Yeah.
As a follow-up to that question, this is part of the question, but this may be more of a police question than anything else. If there's a warrant out for somebody's arrest on a case, how long does it take for that person to get arrested?
It could be years. If you look at the penal code section, there is a section which is failure to join a posse, and I haven't heard any posses being formed recently. But the police agencies generally are not roving around trying to find people with warrants out for their arrest. So we're just kind of waiting for a contact to occur.
Mm.
And
Thank you.
that can be years. Maybe someone could leave the country and then
Right.
years before you see them again.
Right. And Brandon, I think this question is more for you. What is the difference between getting a public defender versus hiring your own private defense counsel?
Well, in terms of eligibility, the person has to financially qualify for representation by the public defender's office. So it depends on the person's income level. It depends on their debt to asset ratio. Sometimes one of the criteria that we look at, does the individual own a home? And if so, how much equity does that person have in the home? We do, I think, philosophically, however, want to be able to represent as many people as possible for a variety of reasons. One, because it's extraordinarily expensive to receive adequate representation. Even if you are someone who's employed, the vast majority of the people that are employed probably don't make enough money to receive the type of representation that's required to adequately defend them, especially when we're talking about felony cases or serious felony cases. But at the very baseline level, it's an affordability issue. And I'm assuming maybe I shouldn't assume, but I don't know if they were asking about a kind of the quality of representation. But if they are, I would say that generally speaking, that public defender offices are far better equipped to handle representation of people accused of crimes than, say, a private attorney, because you have the same way the resources of the government are kind of behind the prosecution of people, like with public defender offices, particularly public defender offices in the Bay Area, there are the resources of the government that support the defense of people. And so the government's not only paying for the attorney, it's paying for the investigator, but the social worker, for legal assistance, for research attorneys. So I think that there is no doubt that someone who is represented by an attorney with the public defender's office, particularly Contra Costa, is going to be in much better hands.
Thank you. And then I think this question is going to actually go to family court, but I'll read it. What should one parent do when the family court allows visitation with the other parent, but there is a substantiated child abuse case against that parent?
I guess that depends on what the word substantiated means, but if a crime is occurring, then the party who's aware of it should report that to police. Yes, you can go into family court and say, this is what's happening, and I want to not have visitation occur anymore because I believe that the child is in danger. And the family court judge would make a decision. But if there's a crime occurring, then report that to the police.
Yeah, thank you. I think those were all the questions. Did anyone else have questions that, while we have Brandon and Eric here, that folks wanted to ask? One of the things that comes up a lot at the Family Justice Center that we have to help clarify for clients is the district attorney's office is not an attorney for the victim, correct?
Correct.
Who are they an attorney for?
So the client of the district attorney's office is the people of the state of California. And so we're enforcing the law, upholding the law, which was democratically enacted by the people as the source. So that's who we represent. When I'm in court, I will advocate on behalf of the victim. So even if maybe sometimes the victim might want a peaceful contact criminal protective order, whereas I believe that it should be no contact, I will still let the judge know that the victim wants it to be peaceful contact and like to address the court on that basis. So we'll do that. So you're still advocating on behalf of the victim, but you do not represent the victim. And then to sort of go back to the beginning of the presentation when I was posing what's the difference between criminal law and civil law, right? If we didn't have criminal law and every time that someone harmed another person, it was just a tort action in civil law, then if the victim decided not to press charges anymore, then that would be it. The case would be dismissed. And she's attorney would be representing him or her directly.
Got it. Thank you. All right, I'm not seeing any other questions. Oh, just kidding. Can the DA obtain pictures, evidence from the police to provide during a court date? I think this person might be asking about a specific case. It's going to depend on what type of court hearing it was.
Right. So a district attorney is only going to be present in a criminal case, not in a family court case or a civil case. Because that's okay, criminal court. So in terms of the photos that might exist, generally those should be provided to law enforcement. Law enforcement would then write a report about how they came into possession of those photographs, and then that would be shared with our office. And whether new evidence would be presented in court depends on the posture of the case and what it is that a DA would be wanting to achieve at that time. So you might learn about new evidence, but maybe the next court date is a setting, not a preliminary hearing or a trial. And you wouldn't be letting the judge know that this new evidence exists because it's going to be irrelevant for that court date.
Oh, okay.
That makes sense.
Yeah, it does.
I don't know enough information to be able to answer that concrete question.
Right.
That's kind of the parameters.
And then we had a couple more come in. What is the standard in terms of, we have a lot of folks, especially at the Family Justice Center, but I think several different agencies that are on, where a client might have a restraining order after hearing in family court or a criminal protective order, and the individual causing harm violates that order, and the person reports it to police. What is the standard that you all look for in terms of violation of restraining orders to charge a case?
So that goes back to the beginning of the presentation, which is I've got to have proof beyond a reasonable doubt that 12 people who live in the Bay Area are going to vote to convict.
Okay. Another person is asking, what would be the best way to help? They specifically ask about an elder or dependent adult get a case filed, but in general, you would want to go to the law enforcement agency, the police first, to report a crime, right? That's the only way to get a case filed in the DA's office.
For the most part, yes. Okay. There are exceptions, but that's the largely preferred method.
I'm not sure, does the Family Law Center, are you talking about the Family Justice Center? So we do have attorneys that work out of our office. They are not district attorneys. They do not do criminal cases. The attorneys at our office represent or work in family law and immigration law. But they are their own they have their own private law offices. So typically what they'll do is they'll give consultation advice for our clients here in Contra Costa County. These are great questions though, everybody. Thank you. I think those are all that we had. I can't thank you both enough for being here today and answering. We had like 20 minutes of questions. So I think people are really engaged and really curious about the criminal justice process and how things happen and when things get filed and when they don't. And appreciate both of your time for being here.
Of course, happy to be here.
Thank
Thanks for having us,
you.
and thanks everyone for coming.
Yeah, thank you so much.
And then we'll be sharing these slides for today with you all, and then we'll have the recording uploaded probably either today or tomorrow on the Contra Costa Family Justice Center YouTube channel. So we'll send the link out for that as well. We're also going to be sending out an evaluation on how we did today. Please, 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 it'll take you 1 minute to go through it. We do look at those because if there's something great, we want to be able to congratulate Eric and Brandon. If there's something we want to work on, we want to be able to fix that for our next trainings. So thank you all so much for being here, and we'll see you at our next Family Justice Institute training. Have a good day, everybody.